and welcome to another edition of our new board member series. And as Greg mentioned, we're going to be covering the Open Meetings Act today. And I can safely say probably 75% of the questions I get from board members relate to the Open Meetings Act. We only have an hour today, so I'm only going to kind of scratch the surface of the Open Meetings Act. As the presentation title indicates, we're going to be focusing on the do's and don'ts of OMA. So without further delay, let's go ahead and get started. So our overview, in order to understand the Open Meetings Act, we first have to look at the general requirements and then the terms within those requirements and kind of digging below the surface into those terms and how those terms are defined and how they're interpreted by our courts. So that's how we're going to kick things off this afternoon. And within that area, we're going to also focus on committee meetings and electronic communications. From there, we're going to transition into closed meetings. This is the greatest liability or greatest area of liability for school boards and other public bodies in terms of complying with the Open Meetings Act. When I see OMA violations, it's usually a result of illegally meeting in closed session. From there, we'll look at public comment, just a few quick slides on public comment and the rights that your community members have to engage the board or address the board via public comment. And of course, we have to address virtual meetings today. I'd be remiss if we didn't address that topic. So we're going to conclude with that, as well as enforcement and penalties regard to the Open Meetings Act. And hopefully we'll have some time for questions at the end of the presentation. But I did indicate to Greg that I'm more than happy to address some questions throughout the presentation as time permits. So first, let's take a look at some key provisions here. And these kind of relate to the do's of the Open Meetings Act, what you're required to do under the law. So all meetings of a public body shall be open to the public. And we're going to focus on those two terms there, meetings and public body, how those terms have been defined not only in law, but how they're interpreted by our courts as well. Second bullet point. All deliberations of a school board constituting a quorum of its members shall take place at a meeting open to the public unless a closed meeting exception applies. Now, I want you to take a look at that requirement and think about how that may apply to board members texting each other at an open meeting. And we'll address that issue in a bit, but before we do that, I just want you to think about that and see if you come to the correct conclusion, whether that is a do or a don't in terms of the Open Meetings Act. And then all decisions of a public body shall be made at a meeting open to the public. So what constitutes a decision? We'll take a look at that. The big issue in terms of when you're making a decision as a school board is whether you're in open session or closed session. Obviously, you're required to make decisions at an open meeting that follows the requirements of the Open Meetings Act, but you cannot make a decision in a closed meeting. And we'll dig a little bit deeper into that issue as well later in the presentation. So let's first take a look at the definition of a public body. Clearly, school boards are public body, no doubt about that. But when you look at this definition, this would not cover, for example, a booster club board, or maybe a PTA or a PTO board. Those are considered to be private entities. They are not a state or local legislative or governing body, such as a school board. And the MASB, Board of Directors, we're not a public body either. We're a private, separate 501c3 organization. Even though we have a close relationship with school boards, we're not a public body for the purposes of this definition. Note that this definition also includes the term committee. And that brings us to the question of whether a committee of a school board could be a public body or not. Now, because a school district is governed by its school board, a committee of a school board is considered to be a governing committee for the purposes of this definition. So, is your school board committee a public body? Well, when you go back at that definition, when you look at that definition, it very well could be. If your board is empowering that committee to perform a governmental function on behalf of the board, that committee becomes a public body. So in other words, if the committee is empowered to act on issues, matters that would deprive the full board of the opportunity to vote on that issue, that committee is performing a governmental function and has exercised governmental authority, and the committee is a public body for the purposes of the Open Meetings Act. On the other hand, if the committee is just limited to gathering information and it has absolutely zero authority to make a decision on behalf of the board, that committee may hold a meeting and it's not subject to the requirements of the Open Meetings Act. So this is an issue that is going to be dictated by kind of the local facts of your situation. First, how was that committee created, and what type of authority does it have, or how it's been, what type of authority has been given to it by your local school board. So some committee dues. If your committee is in fact a public body, so it is performing a governmental function on behalf of the board, it must comply with the Open Meetings Act. And what it must do then, it must post all of its committee meetings. All those meetings must be available to the public. And this third one surprises a lot of folks, is that you also have to offer public comment at those committee meetings. And the public comment may not even relate to what the committee is addressing. It could be anything that's within the jurisdiction of the whole board. And then if the committee is in fact making decisions, those decisions must be made in open session. And then lastly, the committee must take minutes as well. Now, this is, again, a fairly complicated issue. So I don't have much time to go into detail on it, but what I can tell you that look in your next edition of MASB's Leaderboard magazine for a more detailed analysis on this issue. In my Ask Brad column, usually appears on page 9 of Leaderboard. And I am, because this has been such a common question within the last 6 months, our committee is subject to the Open Meetings Act, I decided to address it in that column. So within the next, I'm not sure when our publication date is, but it's a spring publication date. So look for that article in the next edition of Leaderboard magazine. Let's transition into the definition of a meeting. You can see the definition there focuses on whether a quorum is present for the purpose of not only making a decision, but also deliberating toward a decision on public policy. So a lot of folks, they kind of misconstrue this definition that, oh, if we're just deliberating as a board, we're not required to do that in an open meeting under the requirements of the Open Meetings Act. But that definition also includes the element of deliberating toward a decision, which means that decision-making isn't the ultimate threshold element of this definition. So those meetings that boards refer to as workshops, retreats, work sessions, study sessions, committee of the whole meetings, even though these meetings are just discussion-only gatherings, they still qualify as meetings under the Open Meetings Act and must be posted as meetings. And again, you must allow public comment at these meetings, and minutes must be taken at these meetings as well. Now, be careful not to splinter the quorum or create a constructive quorum. So even though when you create a constructive quorum or splinter the quorum, a quorum of the board isn't present at one of those gatherings, you still could be having a meeting as defined under the Open Meetings Act if the discussions that occur in those sub-quorum meetings are shared with enough board members, so a quorum of the board is deliberating on matters specific to the school district or the school board. That's called splintering the quorum or creating a constructive quorum. So I have an example of that. This happened a few years back. You had a school district where the employees of the district requested to meet with members of a 7-member school board to discuss personnel matters. So kind of a bad idea to begin with. You have employees wanting to circumvent the administration, requesting to meet with members of the board. The meeting began just with 3 board members. So the board was aware that because this wasn't being held as a meeting under the Open Meetings Act, only 3 board members could be present to meet with these staff members, but a 4th board member eventually arrived. So the board members who were present came up with the idea, well, let's kind of rotate a board member in the meeting and have, when that person comes in, another person will leave. So they were meeting in a room And three board members would engage in discussions with the staff members, and then a fourth board member would come, and then another board member would leave. So they would do this every 15 minutes. So not at one time was a quorum of the board meeting with the staff to discuss their concerns. This was reported to a local county prosecutor, and it was investigated, and the prosecutor determined, yep, that was a constructive quorum, and a meeting did occur because of that. And because it wasn't a posted open meeting, it was a violation of the Open Meetings Act. So an example of creating a constructive quorum, just avoid structuring mini meetings that include less than a quorum of the board, but information is shared amongst a quorum of the board via those sub-quorum meetings. So I'm going to pause at this point. Greg, do we have any questions?
Yeah, so we have two kind of specific examples around whether or not these would be considered. So one, I'm going to throw this one at you from Beth. Is having lunch with 4 board members outside of the school, is that a OMA violation?
That's a great question. I'm going to address that in the next slide.
Perfect. And then would a budget workshop where no decisions being made need to be made public?
And we're going to address that question right now as well.
Perfect. Those are all we have right now.
All right, thanks, Greg. All right, so let's look at it on the other side now, where you have a quorum of the board present, but you're not required to comply with the requirements of the Open Meetings Act. These are referred to as permissible gatherings, and they're very limited, but the Attorney General has issued a couple of opinions on what constitutes a permissible gathering. So the first example I refer to as the MASB exception. It allows you to attend a conference or a workshop as a quorum of the board, and you don't have to post that as a meeting under the Open Meetings Act. But look at these 3 specific elements. First of all, the purpose of the workshop is to consider broad issues. So not specific to your local school board, but these issues cover all school boards in Michigan. That's the first element. It must be open to other members of the school, of other school boards, or to the public in general. And the members of the board, of course, must refrain from any type of collective deliberations on public policy relating to this district while attending the event. So you can come to the MASB's annual leadership conference as a full board and attend sessions together. And you meet all 3 of those elements. But what you can't do is at lunchtime kind of gather as a board and start discussing, wow, that was a great clinic session. How are we going to apply that in our district, and start deliberating on that? That needs to be done at a public meeting, not at lunchtime during our ALC. So going back to that question of whether a school finance workshop for your board constitutes a permissible gathering, or is it a meeting under the Open Meetings Act, you really focus on those first 2, all 3 elements here. Is the purpose of that workshop to consider issues broader than what is specific to your school board? Is it open to other school boards? Most likely not. And then third, are you refraining from deliberating as a board while you're getting information from that workshop that is specifically structured for your board? So based upon that analysis, I would say a financial or a school finance workshop for one board of education would have to be posted as a meeting under the Open Meetings Act. It likely wouldn't meet this exception. Now, the lunch exception, or the lunch question that Greg brought up, is covered by the social or chance gathering exception that constitutes a permissible gathering under the Open Meetings Act. As long as a board meets for just purely social reasons and you're not discussing any school district business, yes, you can have lunch with 3 or 4 other board members. You can go to an athletic event or a fine arts event together as a board, to kind of show that the board is there, showing that the board's interest and being a part of the school community. That would constitute a social gathering. Another example would be graduation. Hopefully in the next couple months, we're going to have fairly regular graduation ceremonies. We'll see what it looks like in May and June. But the board could attend in person. The at the commencement ceremony, and that would not be a public meeting under the Open Meetings Act. That would be a social gathering there. You're just there as as a board to show your support for the graduates. Another example of a permissible gathering, presentations by groups. So the board attending a Kiwanis meeting or a Lions Club meeting, some other community organization that's holding a meeting and has invited the whole board to attend. You can attend as a quorum, but again, you're just there listening and you're not deliberating as a board about the information you're receiving at that meeting. And the last example of a permissible gathering would be very unusual, but let's say 4 board members are subject to a recall election. Those 4 board members could meet together and strategize how to defeat that recall election, and that would not be a meeting under the Open Meetings Act. So those are permissible gatherings when you can have a quorum of the board together and the requirements of the Open Meetings Act do not apply. What about emails or texts? Could board members texting each other or emailing each other violate the Open Meetings Act? Yes, what you have to do is you have to go back and look at that definition of a meeting. So do you have a quorum of the board deliberating via emails about a school district matter that they're going to be deciding on at a future board meeting? That would be a meeting under the Open Meetings Act. And if that occurs electronically, that is a violation of the Open Meetings Act. Now, a 2-way email exchange between 2 board members, that's going to be permissible as long as it's just limited to 2 board members. And the Open Meetings Act also doesn't prohibit board members or your board president or maybe your superintendent's executive assistant or even the superintendent, from sending out a one-way communication to all 7 board members. That's just a great way to share information, and that is not a violation of the Open Meetings Act. So just a few best practices when it comes to using email. Don't use the reply all button. Okay, that's particularly a mistake when you get a communication from your superintendent and you have some thoughts on that and you respond and you hit reply all. What you've done at that point, you started a deliberative process. So certainly you want to avoid that. Don't send sequential communications. This would be similar to splintering the quorum or creating a constructive quorum, where you're adding your opinion to an email and forwarding on to another board member. It starts out okay, maybe email between 2 or 3 board members, but then once it reaches the 3rd or 4th or 5th board member, then it becomes problematic. So avoid those sequential communications. Do consider using blank copies. Now, I'm not going to say that this is a fail-safe way to avoid violating the Open Meetings Act in terms of sending emails, but it's a good practice. So if you send an email out to 6 other board members, you send it to one individual and then blind copy the 5 other board members. And if someone hits reply all, it only goes back to you, okay? It doesn't go to the other members of the board. Now, if you have multiple emails that include multiple blind copies, I'm pretty confident you're going to start a deliberative process by a quorum of the board there. So don't think that, just because we're sending 10 emails and everyone has being blind copied on it, that we're safe from violating the Open Meetings Act. That most likely wouldn't be the case. And consider also including a do not copy or forward alert when you're emailing a message concerning school district business to your colleagues on the board. And you see an example here that I provided in the slide. So before we get on to texting at board meetings, any questions, Greg?
Yeah, just a few. So again, more specific. So what about a series of one-on-one conversations with a board president and each individual board member that addresses an issue coming up at a future meeting? So what does that look like?
If the communications are kept between the 2 individuals, so the board president may be canvassing each board member, that would be fine. But what the board president can't do is share what the board president has heard from other board members in the subsequent communications. And we'll talk a little bit about canvassing your colleagues on the board in a minute.
Great. How about this one? So prior to a committee or a board meeting where deliberation or decision-making is to occur, is it a violation of OMA if a document is on a shared drive and board members are asked to review and make comment?
Yeah, I mean, arguably that could be the situation of, again, creating a constructive quorum with that Google Doc. I would advise against that. Now, I can't point to any case law or any attorney general opinions that address that issue of whether using Google Docs violates the Open Meetings Act, but certainly I would advise against it.
Great. So there's an example in here as part of onboarding new board members. Say a particular district has 4 new members. They also have their members meet with member of cabinet to develop an understanding of the cabinet member's role. This is not meant to be interactive. It's considered more training. Is this a public meeting?
I don't believe so. I think in that case, you're really not deliberating about public policy issues relating to the school district. That sounds more like training orientation, where you're just sharing with board members, whether it be the job responsibility duties of administrative staff or their duties and responsibilities as a board member. So I think in that case, you really wouldn't have deliberations on public policy by a quorum of the board.
Great. So another example, say board members want to have a community engagement committee to connect with their community and foster relationships. Are there any guidelines around that you can allude to?
I think in that case, I would post it as a public meeting, a community engagement committee that involves the board, post it as a public meeting and comply with all the requirements of the Open Meetings Act.
Perfect. One that just came in around email, so I'm going to jump to that one. Is it okay to send an email to 2 other board members? The slide said direct to 1 only, but 3 are allowed to meet face to face. So can you talk about why there's a difference there?
It's I use the example of a one-on-one communication, based upon having a verbal conversation with one individual. That used to be the only way to communicate. I guess you could possibly bring someone in through a conference call, but yeah, now with electronic communications, bringing a third person in with email would be fine, but again, has to be limited to just three board members. That would be okay.
Great, thank you. Something around the Zoom and virtual space. So if there's a meeting and the host loses their internet and cannot reconnect, is continuing the meeting a violation of the OMA?
Again, really no guidance from the courts on that issue. Probably the best practice would be if someone does lose a connection and that person really wishes to participate in the meeting, I would suggest recessing until possibly that person can reconnect. But again, not much guidance from the courts on that matter.
Thank you, Brad. And then we have one final general one, and I'll hold one final one until you get more to canvassing. Someone asked, is there a statute of limitations for OMA violations?
Yes, there is. And I want to cover that today off the top of my head. I believe it's 60 or 90 days from the point of the violation, depending upon what the board was acting on.
Perfect. I think that's all we have, so we can continue on. And then there's one that I'll ask a little later.
All right. Thanks, Greg. All right. So when we looked at those general requirements of the Open Meetings Act, I asked everyone to think about that, the requirement of deliberations occurring at an open meeting, how that requirement would apply to board members texting each other during a board meeting. And the Attorney General has addressed this issue. Now, this is informal guidance. It's not included in a published Attorney General opinion, but is included in the AG's handbook on the Open Meetings Act. And in there, it indicates that email, texting, or any type of other electronic communications that occur amongst members of a board during the course of an open meeting constitutes deliberations toward decision making, which violate OMA. because, according to that requirement that we looked at, all those deliberations must be open to the public unless a closed meeting exception applies. So if you're texting another board member during a meeting about an issue that the board is discussing, those are secret deliberations during a board meeting. And according to the AG, that's essentially closed meeting communications without a closed meeting exception applying, and that would violate the Open Meetings Act. So let's take a look at decision making. Now, the definition of decision making is what you would expect: making a determination, taking action, voting on a motion or a recommendation, or something that's proposed to the board. That's essentially what a decision is and how it's defined under the Open Meetings Act. Now, what you have to think about as the board is, are we making a decision when we are building a consensus? And if you do that outside of a meeting, that would violate the Open Meetings Act. So board members using electronic communications or sub-quorum meetings to come to a consensus, which essentially is a decision, and if that could have been achieved in an open meeting, likely a violation of the Open Meetings Act. However, as I mentioned previously, that does not prohibit one member of a school board from contacting another member to canvass where that individual is going to be on a particular issue. And the example I like to give is when you're doing your officer elections. Maybe you don't want to nominate someone who isn't going to be elected. So what you can do, you can say, I'm going to nominate Greg for president. And you can contact each board member and say, would you support my nomination of Greg for president? And you can go down the line contacting each specific board member to see if you have enough votes to get to that majority vote to elect Greg as president. That's canvassing, and that is permissible. What you can't do is kind of share information along the way. When talking to board member number one, he's going to support Greg, but then you talk to board member number two and trying to convince her to vote for Greg's nomination. You can't say, well, board member one's going to vote, so I think vote for him, so I think you should vote for him as well. So that's canvassing, but again, don't splinter the quorum or create a constructive quorum when you're going through that canvassing process. Conduct votes in a way that a person attending the meeting or reading the minutes can hear or see how each board member voted. Okay, so what that means, you can't use any secret ballots or you can't do any secret voting. Now, what that doesn't mean is that you have to do all votes by roll call vote. You can do yay, nay votes, but particularly if all the votes are 7-0 votes. If you have a historically split board and you have a lot of 5-2, 3-4, 4-3 votes, you may want to do all your votes by show of hands or roll calls, just so people clearly see how each board member is voting on a motion that's before the board. But that's required under the Open Meetings Act, required by the school code as well. So again, do not use any type of secret ballot in arriving at a board decision, whether it's the final decision or preliminary decisions to that final decision. You'll see secret ballots used in filling a vacancy when you have multiple candidates for that vacancy and you want to narrow the pool. And it may be used when hiring a new superintendent as well. If you're using a ranking process, those rankings cannot be secret, okay? Any type of ballot, any type of ranking, when it's leading to a final decision, has to be done openly. So those results have to be announced. The rankings have to be announced. That board member one ranked the candidates in this order. Board member two ranked the superintendent finalists in this order. And then that has to be recorded in the minutes. If you don't do that, then that constitutes a secret ballot under the Open Meetings Act and would be contrary to the act. So closed meetings, decisions versus deliberations. So the Michigan Court of Appeals had ruled that a public body will violate the Open Meetings Act when it uses an informal voting procedure in a closed meeting. So in most cases, when you're in open session, it doesn't matter whether you're deliberating or making a decision under the Open Meetings Act. Both of those must be done in an open session, but it becomes significant when you're in closed session because you can't make a decision in closed session. So you always stop short of making a decision in closed session. And this is where it's very helpful to have a seasoned board president who understands this requirement. Because the board president, I see as being the gatekeeper of closed sessions, ensuring that the board isn't violating the Open Meetings Act when it meets in closed session. The board president should ensure that, okay, we're always stopping short of making a decision in closed session. We're just deliberating, and when we're ready to make a decision, that's when the board president says, okay, let's go back out in open session and we can cast a vote on this one. So on that point, Greg, I'm going to take another break here for questions.
Perfect. We do have a few, a couple around meetings themselves. So say someone passed a note to their president during a school board meeting to go back to an agenda item. Is that also a no?
That's funny because, before texting and emailing, it wasn't uncommon to pass notes during a board meeting. And there wasn't any guidance from the AG or otherwise saying that passing a note during a board meeting constituted a violation of the Open Meetings Act. But when you do it electronically, then I guess there's more risk there. Again, there's really not a case that says that's a violation. I guess my advice would be just refrain from passing notes during a board meeting. I'm not going to say whether that's a violation or not. Just simply say, make that comment, say point of order. Should we readdress this issue on the agenda?
Great. Another one on the specific question around Zoom internet loss of service. If the loss of service is by the host, i.e. the public body, so all outside attendees are cut off, is that a violation to continue the meeting?
Again, if it's a pure virtual meeting in whole, where all your community members are participating virtually, best practice would be to recess that meeting. If the community does not have the opportunity to attend that meeting or address the board for public comment, it should be recessed.
Great. So one about sending information via communication. So when sending information to the entire board regarding things like legislative updates, is it okay to forward the information to all members if in the subject line it states for your information?
Yes. Yep. That would just sharing information is fine, as long as we're not commenting, forming opinions, deliberating on that information.
Okay, and final one, can the superintendent request their review in closed session without the rankings made public?
So and we're going to talk about evaluations in closed sessions in a minute. And yeah, under the Open Meetings Act, you can deliberate toward a decision in regard to the superintendent's evaluation in closed session, but any decision relating to that evaluation must be done in open session, and likely the rankings would be subject to FOIA. Now, there is a very unique exception in FOIA called the frank communication exception that possibly could apply to rankings that are deliberated on in closed session, but that is a fairly complicated analysis and really would be very factually specific.
Wonderful. Thank you, Brad. And that's all we have right now.
All right. Thanks, Greg. So you see on this slide, here's my top 5 closed meeting don'ts. First and foremost, you see the one we've been looking at or discussing, making a decision in closed session. This is what I read about, hear about most often, the board making a decision in closed session. Don't do that. Discussing individual administrative contracts in closed sessions. We'll find out in a bit. Open Meetings Act allows you to discuss a collective bargaining agreement in closed session and strategize relating to negotiating that agreement, but that does not apply to individual contracts. So your superintendent's contract should not be discussed or negotiated in closed session. Citing personnel matters as a reason for calling a closed meeting. On the next slide, you'll see that there are a number of reasons to go into closed session relating to a personnel matter, but you have to be specific when you move to go into closed session with your motion, and you simply can't cite personnel matters because there isn't a general personnel matters exception under the Open Meetings Act that allows you to meet in closed session. Number 4, discussing an oral legal opinion from legal counsel without a pending lawsuit. It has to be a written legal opinion from your legal counsel in order to legitimately meet in closed session. And we'll discuss the reasoning behind that in a minute. Then lastly, exceeding the scope of the closed session. So this is when a board legitimately meets in closed session, but while in closed session, the communication and discussions are flowing rapidly, and it starts deliberating on an issue that isn't covered by a closed session exception. That would be exceeding the scope of the closed session. So those are the top 5 closed meeting don'ts. Avoid these if you can. So these are the do's, legal purposes for a closed meeting. And I've highlighted here by bolding the text, some of the important elements of these closed meeting purposes. Number 1, considering complaints, discipline, and evaluations relating to employees or board members if requested by the employee. This is the one that would relate to the superintendent's evaluation. So you can only go into closed session if the superintendent has requested a closed session for his or her evaluation. Now, it would be unusual for a board member, for a superintendent to not request a closed session for the evaluation, but it does happen. And if the superintendent has not made a request for a closed session for his or her evaluation, that must be discussed in open session. The board cannot go into closed session without the request from the superintendent. Same rule applies for a student discipline hearing. You can go into closed session to consider disciplining a student, but if a parent, for maybe PR purposes, wishes to have the full discipline hearing in open session, that's the parent's call. If the student is under 18, if the student's 18, then the student can make that decision. But the board could not go into closed session to discuss that student discipline issue without the parent requesting the closed session. Number 3 is what I referred to on the previous slide. You can only go into closed session for negotiating a collective bargaining agreement. This does not apply to individual administrative contracts, so this exception does not apply to your superintendent contract. And note that on 4 through 8 here, I've noted those closed meeting exceptions with an asterisk. That signifies that those require a 2/3 vote to go into closed session. So 1, 2, 3, only a simple majority vote to go into closed session, but 4 through 8, you must have 5 board members present to go into closed session. So if you have your bare minimum quorum present at a board meeting, meaning only 4 board members are present on a 7-member board, you could not go into closed session to, for example, consider the purchase or lease of property. That would have to wait until the next meeting where you have at least 5 board members present. And note that it only covers purchasing property. So if you're building a new school building, you can go into closed session to discuss purchasing property for that new building. But if you're selling an old building, that would have to be discussed in open session. Number 5, going into closed session with your attorney to discuss specific pending litigation. And I've highlighted the term specific because you have to identify the pending litigation. You simply can't say closed session for pending litigation. You actually have to cite the case, whether it's a tenure case, whether it's a unfair labor practice case, that has to be cited in your motion according to a recent court case. Number 6, if you're going through a superintendent search, you may possibly utilize this exception, going into closed session to only review applications for employment if the applicants request confidentiality. Now, almost all superintendent application platforms have that question. Are you requesting confidentiality? And almost 100% of the applicants say, yes, I would like confidentiality. So that would allow you to go into closed session, and some boards and some search services will utilize that exception. MASB does on occasion, but we don't make it a common practice because of the possible risk of violating the Open Meetings Act, because it's a very limited exception. You only go in to review applications. You can't make any decisions while you're in closed session. And that's what boards will do. They'll feel comfortable about when they're in closed session, and they'll start narrowing the pool of candidates while they're in closed session. That's not permitted. Okay? Only reviewing the applications if confidentiality is requested. Now, number 7, this is your attorney-client privilege exception, even though it doesn't say it. How does this relate to the attorney-client privilege? You have to look at the Freedom of Information Act. So what this one states is that you can go into closed session to review material that's exempt by another law, whether it be a state law or federal law. Under the Freedom of Information Act, a written opinion from your attorney that is protected under the attorney-client privilege is confidential and is not subject to public disclosure under FOIA. That means because it doesn't have to be disclosed under FOIA, you can take that written opinion from your attorney into closed session. Again, it cannot be an oral opinion, it has to be a written opinion in order to apply to that particular exception. And number 8 is our newest closed meeting exception, allowing you to go into closed session to consider security planning, either to address an existing threat or to possibly prevent a potential threat. So those are the closed meeting dues. When you can legally and legitimately meet in closed session, courts interpret these very narrowly. So do not read into them, do not overinterpret them, kind of interpret them as they are written. And on that note, we're going to transition to public comment. But before I do that, Greg, I can answer a few questions.
Wonderful, thanks, Brad. One around closed session, can you meet with your district's legal counsel for their legal opinion during closed session?
Yes, but it has to be a written opinion. If it's not a written opinion, that one exception we just looked at does not apply. On the other side of it, though, if it involves pending litigation, and you don't have to have that written opinion, but you have to be involved in a specific lawsuit, you have to receive the proof of service that shows that you're being sued, and that would allow you to go into closed session with your attorney as well.
Great. A couple questions around committees. Do board committees have to have minutes taken, and are they required to post within a certain time period?
So again, if the committee is a public body based upon that analysis we looked at, then yes, the committee must take minutes for its meeting. Those minutes do not have to be posted, but the meeting of the committee would have to be posted if that committee constitutes a public body. Again, somewhat of a complicated analysis, but look for my upcoming Ask Brad article in the next edition of Leaderboard for additional guidance on that issue.
Wonderful, thank you, Brad. And then in the AG handbook on pages 7, 8, and 9, there is a reference to a committee meeting and an extra board member sits in making a quorum. Can you clarify this? Because this person mentioned certain board members get some information and other board members do not get that information.
Yeah, a question that comes up quite often, and again was the topic of another Ask Brad article, but I don't know the Leaderboard edition off the top of my head. On that issue, I would recommend that fourth board member do not attend that committee meeting, because once the fourth board member attends, it turns that committee meeting into a special board meeting. Okay. Even if you're posting it as an open meeting, it's been posted as a committee meeting. So you're telling the public with that posting, only less than a quorum of the board is going to be deliberating on issues that come before this committee. And if the fourth board member shows up, even if that fourth board member sits silently, there is case law that would indicate that with 3 board members deliberating and a fourth board member listening, that is a quorum of the board deliberating toward public policy, which would constitute a meeting under the Open Meetings Act. So my advice on that, the fourth board member should not attend, but if you have a situation where other board members wish to attend committee meetings, consider having committee of the whole meetings.
Great. And a final question before I turn it back over to you is, can the superintendent canvass and tell the other board members what another board member said?
So there's actually a decision on this about a superintendent canvassing board members, and as long as the superintendent has the authority by law or by policy to make that decision, that would be permissible.
Perfect. And that's all we have. So back over to you.
All right, thanks, Greg. And I think from here on out, I am going to go until the end of my presentation here, just to make sure we cover all the slides. And we may have a few minutes left at the end of the presentation to answer any remaining questions. So let's take a look at Open Meetings Act and public comment. Prior to the Open Meetings Act being amended to include virtual meetings, all that we had in regard to a requirement for public comment was the first statement here, the first bullet point, that a person shall be permitted to address a meeting of a public body under the rules established and recorded by that public body. That was it. the Open Meetings Act did not say anything more about public comment, but you have all these different opinions from the Attorney General. You have court cases interpreting, public comment. So it's kind of funny that, the public comment being such a big issue with school board meetings, that was only the only requirement in the Open Meetings Act that addressed public comment. But now you have these additional virtual meeting public comment requirements. If you're conducting a virtual meeting, you have to permit two-way communication so that public participants can hear the board and can also be heard by the board when they're doing public comment during the public comment period. So there has to be two-way communication, at least during the public comment period. Outside of the public comment period, it would just have to be one-way communication, the members of the community virtually hearing the board. Boards may also use technology to facilitate public comment, have typed comments for public comment. These comments would be submitted to the members of the board during a virtual meeting and would be read or shared with board members to satisfy the two-way communication and public comment requirements. So you could do this in lieu of having real-time virtual public comment. Some boards have done this, others are uncomfortable with doing it, but you would apply your same public comment rules to these type public comments if you do in fact decide to use this option under the Open Meetings Act. And you can also establish and require mechanisms relating to signing up for public comment. Now you can't do that for attending the meeting. For a virtual meeting, you simply have to provide a link to your community, and then a member of the community just simply clicks on that link and attends the meeting. But if that individual wishes to engage in public comment, you can require the person to sign up right up until the point of public comment. And if someone hasn't signed up, at least for a virtual meeting, you could deny that person the opportunity to address the board. But again, you can adopt rules, but you have to remember that these have to be recorded by the school board in order to be enforceable. So if someone just, your board president comes up with a rule without having it adopted by the board, that rule would not be enforceable. So all your rules have to be approved by the school board, whether it's for virtual public comment or in-person public comment. And the standard for adopting these rules, that they have to be reasonable, flexible, and also encourage public participation. That's based upon a old AG opinion, but still relevant nonetheless. So that brings us to virtual meetings, and I would be remiss if I didn't cover virtual meetings today. These are the dates and deadlines of when you can have specific type of virtual meetings. Now, March 31st has passed, so you can no longer have a virtual meeting for any reason. Now that we're in April, you can only have a virtual meeting in whole or in part to accommodate an absent board member due to military duty, a medical condition, or a statewide or local state of emergency. This only applies until the end of this year. Then unless the Open Meetings Act is amended, you would only be able to have a virtual meeting in part to accommodate a board member due to a military duty. So let's kind of dig into these definitions here. What constitutes a medical condition under the Open Meetings Act? And you can see a very, very broad definition. And the Open Meetings Act does not say anything about a board member having to submit medical documentation. So as long as a board member has an illness, injury, or disability, and then it's wide open at the end, or other health-related condition, between now and December 31st, that board member may be accommodated to participate in an in-person meeting by allowing the board member to participate by virtual means. And let's say a board member is quarantining due to COVID-19, and that doesn't actually have a positive test yet, but due to contact tracing must quarantine. To me, that would be a health-related condition, and the board member would be able to virtually participate and vote in a public meeting as a result of that health-related condition. Now, a number of municipalities have been declaring local states of emergency. And this can be declared by a township, a county, a city, a village. And if you're subject to that local state of emergency, that allows you to have a virtual meeting. Now, there are some specific rules that apply to that. So if an electronic meeting is permitted under a local state of emergency, the following limitations apply. So let's say your board is in your school district has multiple townships. Only the board members who live in the townships that have declared a state of emergency may participate in the meeting and vote in the meeting by virtual means. However, if your traditional meeting location is covered in the township that has declared a state of emergency, then you can have a full virtual meeting. Okay, so those are the two kind of limitations to having a virtual meeting when a local state of emergency has been declared. And you see in the first bullet point, if a board member has a medical condition, only that board member can participate virtually. That doesn't open up the virtual meeting to all the other board members. Only the board member with the medical condition has the ability to participate in the meeting by virtual means. So some procedures. You're required as a board to establish procedures to accommodate your absent board members due to those reasons we've been discussing. What's these procedures entail? Well, they must provide for two-way communication. Again, allowing the community to hear what the board is saying, and during public comment, the board must be able to hear members of the community that participate in public comment. And then you have this announcement requirement. This did not apply prior to March 31st. Now it does. So if you are subject to a local state of emergency, or you have a medical condition that allows a virtual meeting, now at the beginning of the meeting, each board member must announce that they are participating remotely, and you must identify your county, and then the city, township, or village, and then state. That is the announcement requirement. You have to verbally announce that, and then it has to be recorded in the minutes as well. The last slide brings us to enforcement and penalties of the Open Meetings Act. So two different areas of liability here. First, you have civil liability. This is when someone from the community sues you for violating the Open Meetings Act. And note that it has to be an intentional violation of the Open Meetings Act, and that can be proven in a number of different ways. And the penalty would be up to $500, but the big one, the big part of the penalty, part of this type of lawsuit, would be paying attorney's fees. Now, likely if it involves a group of board members, your errors and omission policies may apply, and your district's insurance policy could cover those attorney's fees. But again, you would want to work with your insurance company on determining whether that would be the case or not. So that's civil liability. Then you have criminal liability as well. If you have an individual that intentionally violates the Open Meetings Act, that person can be subject to a criminal misdemeanor as well. So this is when the prosecutor would get involved. It wouldn't be a member of the community bringing this type of claim. It would be someone reporting it to local law enforcement investigating, and then law enforcement providing the case to the prosecutor, and the prosecutor makes the determination, whether beyond a reasonable doubt it can be proven that a board member violated the Open Meetings Act with intent. Penalty here would be a $1,000 fine for the first offense, and then if you do it twice, you have a possible jail term of 1 year. Now, my 24 years at MASB, not aware of someone getting locked up for violating the Open Meetings Act, but as you can see here, it's a possibility. And then lastly, a court could invalidate a school board decision if it's been done in violation of the Open Meetings Act. So let's say you make a decision as a board and you decide, no, we're not going to have public comment at this meeting. We're tired of listening to the community complain about whether we're having in-person or virtual learning. So no public comment tonight, but we're going to hire a new superintendent. If you did that, obviously the decision to hire a new superintendent could be invalidated by a court, as long as the public or anyone bringing that complaint can show that first the act was violated, which clearly would be the case. Then the rights of the public were prejudiced because of that decision, which would be the case as well in the example that I provided. And that brings us to 12:56, Greg, and I think we have a little bit of time for questions. So I'm going to stop sharing my screen and present myself for questions now.
Perfect. Thanks, Brad. And we do have a handful. So I just want to preface, if you do have to hop off early, we will be providing a recording of this as well as resources mentioned within the next week. And I'll have us go, I don't want to hang us too far after, so we'll go about 5 minutes extra. And then any other additional questions, as Brad shared, you can either email the legal team, or I did drop the MASB staff website if you want to contact any MASB staff members after today's webinar. So some of the questions that I want to start with is kind of these hybrid meetings. So several mention this scenario. If you're broadcasting your board meeting on Zoom Live, but it is not a virtual meeting, are you required to offer public comment from the Zoom participants?
No, I mean, as long as you don't have any board members participating virtually or voting virtually in that meeting. So a traditional in-person meeting, all voting board members are physically present, but you've decided to allow the community to view the meeting electronically via Zoom. If that's the case, you're not subject to Section 3A of the Open Meetings Act, and you would not be required to allow public comment via virtual means. And you could have what that would be the hybrid meeting.
Perfect. Some of the state of emergency. So if your county is under a state of emergency, can some members participate remotely and some attend in person?
Yes. Yep. There is no requirement that you have a virtual meeting if you're under a local state of emergency. That option is with the board, whether you wish to have an in-person meeting. But when you look at how the language is worded in the Open Meetings Act about shall establishing procedures to accommodate an absent board member due to a local state of emergency, if I'm advising a board, I would allow those board members who wish to participate in the meeting by virtual means to allow them to do that. And then once you do that, though, it does open up the meeting virtually for your community, where you would have to have the virtual communications and allow for virtual public comment.
Great, thank you. And so does the Board of Education have to declare a state of emergency, or is the local government's declaration good enough?
The board does not have to declare a local state of emergency. It doesn't have the authority to do that. So it's going to be your county board of commissioners, your township, your city council, and it actually starts out with the chief official declaring that state of emergency. So it could be the chair of the county commission, it could be a mayor, and then that state of emergency is only valid for 7 days, and then it has to be extended by the governing body of that municipality. And I'm seeing extensions, until May. I'm seeing extensions until the end of the year. It's kind of all across the board with different municipalities throughout the state.
Great, thank you. If a board member goes away as a snowbird or is on a vacation, is it possible to have them call in and be on speakerphone for a meeting? This was a conversation that a recent board had. Yeah,
so I think they could listen to the meeting via speakerphone, but the board member, if the individual does not have a medical condition and is simply out of town on vacation, that board member should be marked as absent, not present in the minutes and during roll call, and really should just be in a listening capacity. Probably wouldn't violate the Open Meetings Act by allowing that individual to make a comment here and there, just like you could allow a member of the community to comment if you wanted to do that. But obviously, absolutely no voting under those circumstances. And again, person should be marked absent in the minutes.
Great, thank you. If a board has one or more board member who has medical reasons to be virtual, are they allowed to continue with fully virtual meetings, or do they have to be hybrid?
They would have to be, it'd be a virtual meeting in part, okay? So only those 2 board members who have medical conditions could participate and vote virtually. The 5 other board members, if they did not have medical condition, didn't have a medical condition, or were not subject to a local state of emergency, those board members would have to be participating in person. and would not be able to participate and vote by virtual means.
Perfect. This one goes back to public comment. So if a board is holding an in-person meeting, can they still allow the public comment by submitting their responses or comments via a Google form or other electronic submittal process?
I would say no. So if you're meeting in person and you're not complying with Section 3A of the Open Meetings Act, that's the section that allows you to have folks register for public comment and have them submit, possible written comments in lieu of real-time public comment. And that section wouldn't apply if you're having an in-person meeting and you're not following Section 3A of the Open Meetings Act. So what I've been recommending to our members as a best practice, Greg, is that if you're having a traditional in-person meeting, I would not open up public comment by virtual means, with your community. I would require them to address the board in person. But you could still live stream the meeting. Obviously, that's okay. Folks were live streaming meetings before we had COVID-19.
Perfect. Thank you, Brad. Someone's asking for a little bit more clarity around having to extend an emergency every 7 days, or they're asking, is the declaration good enough through December of this year?
No, it does not have to be extended every 7 days. So just the initial declaration by the chief officer of that municipality, that's only valid for 7 days. And then it has to be renewed and extended by the governing board of the municipality. And that could be extended forever, how long the municipality thinks is appropriate. Again, I've seen some local emergency orders extended until the end of the year, but that could be rescinded. Hopefully things get a little bit better and we're no longer under these states of emergency, and could be rescinded. But if it's not, that would still be good until December 31st.
Okay, I have three or four more questions in here, so I'm going to cut it off after those.
Okay.
This one is about medical conditions. Do you have to prove a medical condition, or just verbalizing it, is that enough?
I think verbalizing it is enough. It's a very simple and broad definition in the Open Meetings Act. And, I would not advise to a board president or a superintendent to tell a board member, you have to show me medical condition. Now, I'm not going to say that violates HIPAA. HIPAA is somewhat of a complicated analysis in that context. But the Open Meetings Act doesn't say that there has to be medical documentation. It simply says due to a medical condition. So, I would not go down that path as a board president or as a superintendent requiring documentation.
Wonderful. Thank you, Brad. So this question, as a military member, there will be some meetings where these types of individuals will have to attend virtually or not at all. What preparations or considerations need to be made in that circumstance?
With the military member, it's a little bit of a different circumstance. The military member does not have to announce where he or she is located for obvious reasons. And you just have to make sure that there is two-way communications between the board and the individual serving in the military. As long as you have those two-way communications that allows the military member to virtually participate in the meeting, that should be sufficient. And again, there doesn't have to be any type of documentation provided by the military member. It's just simply a request that I'm being deployed. I obviously can't tell you where I'm going to be, but I'd like to still participate in the meetings by virtual means. So, please, accommodate me to do that.
Great. And this one, shifting gears just a little bit, who makes the changes to the OMA? Is it the governor? Is it legislators? Can you talk about that process?
Yeah, it has to be the legislature making those changes. Now, with the Department of Health and Human Service emergency orders, and prior to that, the governor's executive orders, suspended some of the requirements of the Open Meetings Act. But those were more or less temporary. But if you're making a permanent change to the Open Meetings Act, that has to be first approved by both chambers of the legislature and then signed by the governor.
Wonderful. And I think that's a great place for us to end things. I just want to remind folks that Brad or any MASB staff member does not disappear after today. So if you have questions that pop up, please feel free to reach out to them. We hope that you join us for next month's webinar taking place Wednesday, May 12th from noon to 1. We'll talk about what it's like to be an elected official underneath the microscope. So social media, etiquette in the virtual space, and much more. And we hope you are there. And with that, I want to thank Brad so much for sharing all of his knowledge, answering all of the questions. And
one final comment from me, Greg, is that
yeah, absolutely, Brad.
a lot of times, I really appreciate, again, the great questions today and everyone's engagement. But a lot of times after these type of presentations, my inbox quickly fills up. So I would just ask for a little bit of patience in responding to those questions. I'm actually a couple days behind in my emails are currently in my inbox. So it's been a busy time for us here at MASB. So send me a question a day. Give me a little bit of time to answer that.
Absolutely. If only we could clone you, Brad. So I just want to say thank you so much for being here with our new board members today. And we hope all of you still here have a wonderful afternoon and rest of your week.